right, we're continuing on with Chapter 8, Selling Real Property, and we're going to talk briefly about the closing. All right, so when you close, you are at the point when the purchase contract is being performed. There is, either you'll be in an attorney state or what's called an escrow state. The difference between the two of them has to do with who is the third party that's handling the transactions. As you may remember from the video with Barbara Stewart, some states use an escrow agent, which is a neutral third party, and other states have an attorney that conducts the closings. In North Carolina, we're an attorney state, so attorneys conduct the closing. At the closing, the primary documents are the deed, the promissory note, and the mortgage or the deed of trust. The promissory note and the mortgage or deed of trust, we're going to discuss more when we talk about financing of property. Now, for this class, we're going to focus on the deed. In order to have an effective deed transfer, you need to deliver the deed to the person who, the transferee. But the delivery includes more than just handing the paper, handing the deed over to the other person. It also includes an intention. Now, this intention is the intent to immediately transfer title to the grantee. All right, so to immediately transfer title to the grantee. So, while the specific requirements for valid delivery vary jurisdiction by jurisdiction, commonly you need two elements. The first is you need to intend to immediately transfer an interest to the grantee, and there has to be some objective manifestation of that intent. All right, so that's how you transfer it. So you have delivery. If you have delivery, you still need to have acceptance. All right, acceptance means that the person accepts the deed, and acceptance is typically presumed in most states, right? So even if somebody is in a coma and unaware about it, they still will have been presumed to accept the deed transfer. However, if somebody were to choose to say, no, I don't want to accept this deed or this transfer, then you would not have completed delivery, okay? So just remember that caveat. All right, we're going to look at Rosengrant v. Rosengrant. And this is a case, the issue of which was whether or not the deed was legally delivered. The facts of the case were a bit muddy in the sense that Jay, who is Jay Rosengrant, he testified that his uncle wanted him to leave a deed at the bank, and that if something happened to him, then he was to take it and record it. The issue was that enough to have a legal delivery? And the court found that the grantor's intent at the time of delivery was not to presently transfer the title. It was to transfer it when he died. And so what you had there was what's called a symbolic delivery. And that's just a symbolic gesture that's not enough for legal delivery. For legal delivery, you need to have an actual intent by the grantor to divest himself of the interest that he's conveying. And the uncle didn't appear, based on the facts, to have that requisite intent. So the court found that, based on the facts, it was not sufficient enough to to be considered legal delivery. An important takeaway from this case is that delivery is a matter of intention. And you need to make sure you ask yourself whether or not the grantor was demonstrating an intent to immediately give title or interest in his property to the transferee, right? So the intent needs to be for immediate transfer. You don't have to worry about the rebuttable presumptions for the purpose of the exam. The rebuttable presumptions under physical delivery on page 575. Good to know for a bar exam, but I'm not going to test you on it. All right, delivery hypos. So we're going to apply Rosengrant to these hypotheticals. So suppose that S executes a deed that on its face conveys Green Acre to Y. As S hands the deed to Y, S makes one of the statements below. I want you to tell me whether or not delivery has occurred. All right. Statement number 1. I have now transferred Green Acre to you. Give the deed back to me, and I will keep it in my bedside drawer until you graduate from law school. Has delivery occurred? The answer to this question is yes. The words, I have now transferred Green Acre to you, are an indication that S intended to immediately transfer his interest. So that would be enough to find that there was intent. Now it is confusing that S requested that Y give him the deed back, but delivery has already occurred. So as soon as that intent is manifested for immediate transfer of the possession, the elements have been met. All right, here's the second statement. Suppose S says, I want you to have Green Acre, but I want to live there until I die. Would that be sufficient intent? Well, probably yes. So here, S did not say that they wanted to keep the ownership until they died, only that they wanted to live on the property. So as long as there was an actual physical transfer of the deed coupled with these words, then it probably gave Y the immediate remainder interest in a life estate. And so that would probably be sufficient to find delivery. All right, number 3. What if S said, here's my wife to you. Please hold it safe until I talk with my wife, and then you can record it when I say it's okay. Does this demonstrate sufficient intent for the purposes of delivery? No. This does not indicate an intent to presently transfer interest in a way that is unrevocable, right? This is I'm going to think about it, I'll get back to you later, and that's not going to be sufficient. All right, 4. Place the deed in our safety deposit box, and when I die, Green Acre will be yours. Ooh, this one's a little bit tricky. What do you think? Is this sufficient? No. And the reason is that the words, when I die, Green Acre will be yours, indicates testamentary intent, not present intent to transfer. Testamentary intent is intent to transfer on death, and that is not sufficient to find delivery. You need to have an intent for an immediate transfer. about Vasquez V. Vasquez. This is a case where the grantor gave the deed to their lawyer, and they gave the lawyer instructions to hand it to the grantee when they died. The issue in this case was whether or not the delivery from the grantor to the attorney was sufficient to transfer the property. Court at the bottom of page 577 states, the question is whether the grantor parted with all dominion and control over the instrument at the time she delivered it to the third person with the intent that it take effect as conveyance at the very time of delivery. What does that mean? Well, what the court is saying here is that delivery to a third person can constitute delivery as long as the grantor, the transferor, parts with all of their dominion or control over the instrument, over the deed. So they can't change their mind and at some point decide to take back their interest. As long as the transfer to the third party that is holding it for the grantee is a complete transfer of dominion and control over that, and they can't change their mind and try to take back possession, then it would be considered as sufficient to meet the elements of delivery. Now, the court noted, I think it's worthy to point out, that Juanita, who was a grantor, retained possession of the property until her death. And the court said that's fine because possession is not determinative of whether or not there is delivery. They stated on page 578 what I said, but more eloquently, where the grantor delivers a deed to a third person with the intent to part with all control, the legal effect of the transaction is tantamount to a delivery of the deed to the grantee. All right. So what Vasquez v. Vasquez tells us is that intent to make an immediate transfer is important, as well as making sure to remove the grantor's ability to control taking back the property, right? If we're looking at a third party. So, quick thought question. What is the key fact that distinguishes Vasquez from Rosengrant? Well, the key fact is, I just mentioned it, I kind of gave it away. The key fact that distinguishes Vasquez from Rosengrant is that in Vasquez, the grantor did not reserve the right to retrieve the deed. So because they did not reserve the right to retrieve the deed, delivery was found, elements of delivery were found to have been met. We're going to pivot now and talk about what types of remedies are available to purchasers of real estate if the breaching party fails to perform on a contract for sale, a purchase agreement. So when you take remedies, you will hear that specific performance is not a very popular remedy. In other words, it's not often awarded. What is specific performance? Well, it's an equitable remedy that requires the party that's breaching to actually do what they said they're going to do, to actually perform on the contract. Although it is not commonly awarded in other cases, in relation to real property, specific performance is relatively common. The reason is that money damages, which are the preferred award, have been found not to make the party whole in the cases of real estate or real property. Land is considered to be unique. No two pieces of land are the same. And so courts, in the case of real property, actually prefer to award specific performance because of it. So let's take a look at Gianni First National Bank of Des Plaines. The question in this case is every piece of real property really unique? What about a unit in a large condominium complex? Can we argue that all condos in one building are the same? So Gianni v. First National Bank of Des Plaines demonstrates how courts view property as being particularly unique. So much so that if somebody purchases a specific condominium unit, then even if there are similar condominium units, they would still allow for specific performance because one condominium unit is not equal to another condominium unit. That is basically the takeaway you need from Gianni. It's that specific performance is often awarded in real estate transactions, even when we're dealing with condos. And that's it for this section.